First, I will clarify the issue of the deed of gift between the executors of the estate of the late Mr. Lee Kuan Yew and the National Heritage Board, as I was then the Minister for Culture, Community and Youth. Second, I will elaborate on due processes for proposals on the conservation and preservation of properties. First, let me touch on the deed of gift. From early 2015 onwards, NHB started planning for a major SG50 exhibition on 6 August 2015, just before the Jubilee weekend, and the exhibition was on Singapore's founding leaders. Following the passing of Mr. Lee Kuan Yew in March 2015, NHB was also in discussion with executors of the estate about a donation of artifacts from 38 Oxley Road, which could be incorporated into the exhibition. The deed of gift was not based on NHB's standard agreement. The executors of the estate, namely Mr. Lee Hsien Yang and Dr. Lee Wei Ling, insisted on several unusual conditions. These conditions included the right to buy back the items at $1 so long as the house was not demolished, and the display of the wishes of the late Mr. Lee Kuan Yew to demolish the house. And as members would have heard just now, the deed of gift required NHB to display only part of the demolition clause in Mr. Lee's will. In other words, NHB was to display the first part, which sets out Mr. Lee's wish to demolish the house, but not the second part, which sets out his wish should the house not be demolished. At that time, NHB did not pick up the significance of this partial quote from the demolition clause. Ms. Lee Swetfen, who was then a director on the board of NHB, was also involved in the discussions between NHB and the executors. She supported the conditions stipulated by the executors in the deed, and her law firm, Morgan Lewis Stamford LLC, helped in the process of finalizing the deed. The executors held firm to many of the terms they had stipulated in the deed. For example, when NHB asked to amend the $1 buyback provision, the lawyer for the executors stated that this clause was non-negotiable. While the terms were unusual, NHB proceeded to sign the deed with the executors because it recognized the heritage significance of the artifacts and felt that it would be in the public interest for them to be exhibited. NHB also assessed that several of the objects were in a deteriorated condition and required immediate care and conservation. So NHB signed the deed with the executors on 8th of June 2015. At around the same time, I updated the Prime Minister on the plans for the exhibition and the inclusion of the Oxley Road artifacts in the exhibition, including the conditions stipulated in the deed. And I later shared with him a copy of the deed on 12th of June. As the Prime Minister shared earlier, he felt that the terms of the deed were onerous to NHB, and he told me that as a beneficiary of the estate, his consent for the donation had not been sought. The executors had not informed him of the donation nor the terms of the donation. So NHB was caught in a difficult position. It had signed the deed and accepted the gifts, but it was not clear if the executors were properly empowered to enter into the deed without first consulting all beneficiaries, and this also raises questions about the validity of the agreement. Moreover, the planned exhibition was just 2 months away, and NHB did not have much time left to resolve the issues and then properly prepare for the exhibition. I discussed this with the CEO of NHB, Ms. Rosa Daniel, then to see what could be done about the matter. Given the circumstances, we agreed that it would be better to take a pause and not rush the Oxley Road items for the August exhibition. We could exhibit them at a later stage after the issues had been resolved. So I asked Ms. Daniel to inform Mr. Lee Hsien Yang that we would like to put off the display of the Oxley Road artifacts from the August exhibition and do so at some time in the future. Mr. Lee Hsien Yang responded on 10th of June that this request was unacceptable and would be a breach of a legally binding deed. In fact, NHB had no intention to breach any legal obligation, and Ms. Daniel clarified this point in an email to Mr. Lee Hsien Yang the next day. She said that the minister's instructions are that NHB is not to breach its obligations if it has entered into valid agreements which are binding on it. While the executors were insistent that NHB had to follow through on the exhibition, NHB still had a duty to check whether the deed of gift was in order in light of the different views of the beneficiaries. Hence, NHB wrote to the lawyers of the executors to clarify whether probate had been granted for the will, whether there were any other beneficiaries entitled to the assets of the estate, and if so, whether their consent had been obtained for the gift to NHB. Before responding to these queries, the executors of the estate put out a media release on 11th of June, publicizing their donation of items to NHB. This was a surprise to NHB because the queries had not been addressed. And so NHB issued a statement that same night to highlight that there remained some questions on the deed of gift, which NHB was in the process of clarifying with the executors. On 12th of June, Mr. Lee Hsien Yang replied to NHB that the executors had not obtained probate for the will, but that probate was not necessary for the executors to have the power and authority to enter into the deed of gift. He also said that NHB should not be concerned about the position of the beneficiaries under the will. But this response still left open the question of whether there were indeed other beneficiaries and whether their consent had been sought for the donation of items to NHB for the exhibition under the stipulated conditions. Throughout this period, I was discussing the matter with DPM Teo Chee Hian, as the Prime Minister had said that he would leave it to DPM to handle the specific dealings between NHB and the executors on the deed of gift. DPM Teo's main concern with the conditions was that NHB was being asked to display a partial quote of the demolition clause, which did not fully reflect Mr. Lee Kuan Yew's wishes. He felt that NHB as a public institution should remain neutral and should not be drawn into a private disagreement or be used to present a particular point of view which was incomplete. Nevertheless, after weighing all the factors and considering that NHB had already signed the deed, both DPM Teo and I agreed that the pluses of having the exhibition with the Oxley Road artifacts in accordance with the deed outweighed the potential controversy that was likely to arise. This was a major SG50 exhibition on our founding leaders. We had artifacts not just from the estate of the late Mr. Lee Kuan Yew, but also from the National Archives and the families of other founding leaders, and many of these artifacts had not been displayed before. The artifacts helped to enhance the storyline of the exhibition and to bring out the values of our founding leaders for Singaporeans. Subsequently, on 25th of June, the Prime Minister informed me that he had written to the executors in his capacity as beneficiary, indicating to them that notwithstanding his position on the deed of gift, he would not object to the exhibition as he did not want to put NHB in a difficult position. NHB was thus able to proceed with the exhibition with agreement from all beneficiaries. But as NHB needed more time to prepare, it sought the consent of the executors to push back the exhibition date. Eventually, the opening was shifted from 6 August to 21st September 2015. In fact, I attended the opening with Mr. Lee Hsien Yang, Dr. Lee Wei Ling, and Ms. Lee Swet Fen. The exhibition was very well received, and it has been extended till now. Madam, as I have explained, my discussion with the Prime Minister on the exhibition was in his official capacity, and I shared the deed of gift with him on that basis. And in response to the question from Associate Professor Daniel Gold, the deed of gift did not have a confidentiality clause. If Mr. Lee Hsien Loong had asked for the deed of gift in his private capacity, NHB would have been entitled to give it to him given his position as eldest son and beneficiary of the estate. More generally, in a scenario where items are being donated to NHB from an estate, and NHB becomes aware that one of the beneficiaries objects to the terms of the donation, it will be necessary for NHB to take steps to verify that there is agreement from all beneficiaries. Otherwise, it could face a potential claim from a beneficiary whose consent was not given. In this case, Mr. Lee Hsien Loong told me that his concern was not with the donation of artifacts to NHB, but rather the way it was handled and the terms of the donation, as he had shared in his speech earlier. Despite his personal reservations over how the artifacts were conveyed to NHB by the executors in the deed of gift, the Prime Minister did not instruct me to stop the display of the Oxley Road artifacts in the exhibition. Instead, he asked me to take instructions from DPM on the matter, and that was how the matter was handled. So, Madam, I've given an account of what happened with the NHB deed of gift. Contrary to this being an abuse of power, I believe the matter was handled correctly and above board. Madam, I will next elaborate on the due process that applies to the conservation and preservation of properties, which is something that DPM Teo had also highlighted briefly in his speech. The government undertakes a rigorous assessment process for all such properties before deciding whether or not to conserve or preserve them. And I will elaborate briefly on what this process is. First, government agencies will undertake detailed research on the preservation or conservation merits of the property of interest. Agencies will have to review the historical, cultural, social, and religious significance of the property, its national importance, as well as its architectural merits and rarity. In examining the historical significance of a site, for example, NHB will review how the site has played a role in our national history. And in examining the architectural merits of a building, URA will study which parts of the building are most architecturally significant, or if it's a cluster of buildings, which are the most significant buildings within the cluster. Next, agencies will look into the planning considerations for the property and its surroundings. This includes examining whether there are any technical regulatory requirements which may have an impact on the form of preservation or conservation proposal for the property. Agencies will also review the allowable uses of the site. For example, URA may look at whether a conserved residential building can be adapted for commercial use or for civic and community purposes. But such a change in use will have to be compatible to its surroundings and supported by infrastructural considerations such as potentially a higher traffic count brought about by the change of use. Arising from these planning studies, agencies may then review the need for the government to acquire the property for conservation or preservation. Under the Preservation of Monuments Act, if a building is occupied as a residence and the government chooses to gazette it as a monument, then the government has to acquire it within 1 year of the preservation order, or else the preservation order will lapse. But beyond the legal requirements, the question is whether the planning intent for the conserved or preserved site is best served by having the government owning the site as opposed to leaving it under private ownership. For example, if the intent for the site is to have significant public access and the owner is not prepared to do so, then one option is indeed for the government to acquire the site. Madam, this sort of research work provides important baseline information for all properties deemed to have heritage and architectural value. In fact, that's the norm. Agencies will engage and undertake these sorts of research work to provide the baseline information we need for all such properties. If there is a need to decide on the next step for the property, then the government agencies will proceed to seek views from the relevant stakeholders. Of course, views will be sought from the property owner. Views will also be sought from relevant professionals and subject matter experts. The URA has a conservation advisory panel, while the NHB has a preservation of sites and monuments advisory board. The advisory panels comprise professionals in the building, arts and heritage, and education sectors, and will provide their inputs on the conservation or preservation proposals tabled by the agency. URA and NHB will submit the recommendations of their findings to the respective ministries for a decision thereafter. If the government, acting through MND or MCCY, decides to pursue the conservation or preservation proposal, the property owner will be given the opportunity to respond and appeal. Based on past cases, the vast majority of owners would agree with the conservation or preservation proposals. A few have appealed, but the final decision for conservation or preservation lies with the government. Madam, we should follow this due process for all properties with architectural or heritage merit, including 38 Oxley Road. And in fact, prior to the formation of the Ministerial Committee, various agencies have already been working on this issue. NHB has been documenting the historical significance of the house. MND and URA have been looking at options for the property, as well as the planning and zoning implications arising from the different scenarios. This work was being done at the staff level. Later, in discussing the matter with DPM Teo and various ministerial colleagues, we agreed that it would be useful to have a ministerial committee to coordinate the work across agencies and to oversee the matter. And that's why MND tabled the proposal at the cabinet meeting chaired by DPM Teo on 1st of June to set up the ministerial committee to draw up the range of possible options for 38 Oxley Road. As DPM said earlier, the ministerial committee has no preconceived notion on what to do with the property. But the current government has a duty to do the work now in listing out all the options and to prepare ahead for the implications of each one of them. That is the right and responsible thing to do. Madam, like many Singaporeans, I'm saddened by the events that have transpired over the last few weeks. Many baseless allegations have been made against the government, and I hope this debate will give us a chance to discuss the issues openly, dispel doubts, and strengthen confidence in our public institutions and system of government. Above all, we will continue to uphold the values of Mr. Lee Kuan Yew and our founding leaders and do our utmost to serve Singapore and Singaporeans. Thank you.